Hello, everybody. Thank you so much for tuning in on a Friday. We could probably do something better on a Friday. Oh, wait, it's COVID, so we probably don't. As I've been putting out to the members, is that we are going to discuss the current changes with the Landlord Tenant Board. What does that look like? What does that actually mean? I want to start off with informing everybody that there is a new updated standard lease. So make sure that you get on the government website to be able to get that. My desk is full of papers right now, absolutely full, because there's a lot that's on the go. Number two, that if you go onto the Landlord Tenant Board website, there is a consent to service by email, which is a little wonky because it would talk about you can send notification and documents to email for notice of entry, as well as for rent increase. It says documents or submissions related to the RTA application, except a notice of hearing, copy of the application, motion, or request for review. So if you're gonna do 1 and 2, why not do all of it? Just a thought, I want your opinion on this. Please get into the comments. Tonight is about me giving you this information, getting your opinion on it. If you like it, if you don't like it, what would you like to see it change to? We have a meeting with the Landlord Tenant Board on the 8th, and I want to be able to bring your voice to them. So please jump on, get your comments. I got my glasses on, so I'm going to be able to see it. And I'm really close to the computer, so it's great. So again, a part of the standard lease, it allows that section to put the tenant's email address in there as well as yours. So they talk about how a consent to service by email may be revoked at any time by giving this notice in writing to another person. So the point of this form, I don't know. This is what the Landlord Tenant Board likes to do, contradict what they're trying to do. They have the advanced resolution request form. So make sure you get in to take a look at that. Again, it's really about withdrawing, discontinuing your type of application and having something in place where they can just get this off of their docket and not have it brought to the Landlord and Tenant Board. There's a few other things that I have here tonight. We have the schedule for an hour and a half. Hopefully I'm not going to be on here completely for an hour and a half. But I read it last night before bed, and I should have watched a horror film because the one thing that I read was absolutely scary, really, really scary. So we won't give you the bad news quite yet. We want to get into the concept that we got notification from the Landlord Tenant Board informing us. Let's see here. So the Landlord Tenant Board is transforming its services to meet the needs of landlords and tenants by conducting hearing by telephone, video, and writing where feasible, shifting resources to prioritize the scheduling hearings, conducting case management hearings for contested L2 applications to end a tenancy to evict a tenant, expanding the capabilities of the Landlord and Tenant Board to handle incoming documents by adding 3 new fax lines. How exciting is that? Developing a new digital certificate stamp for orders to be sent to parties by email. That is huge. I know there's a lot of you that are having your hearings and you're still waiting for almost a month for that order to come into the mail. So with this new digital certificate stamp, this is something that it could be automatically sent to you or when they write it, but it should be a lot faster than snail mail. They encourage applicants to use electronic filing to allow LTB to process applications more quickly and include their email address on the application to save time, and implementing the advanced resolution request form to allow applicants to quickly resolve matters that are not complex and may not require a hearing. They have appointed 39 full-time adjudicators and 35 part-time adjudicators to hear Landlord and Tenant Board matters. So that in itself would be, hey, this is why we're getting a lot of headlines now calling the Landlord and Tenant Board the eviction factory. But it's still not as quite as they think it is. It's more of just something to grab some attention. They also stated that additionally, we would like to provide an update to the consultation with the stakeholders and the public on the proposed changes of our rules, guidelines, forms held in August. Over the consultation period, the Landlord and Tenant Board received 44 comments and held 15 virtual meetings with stakeholders. The Landlord and Tenant Board was reviewed the feedback and finalized its rules and guidelines to support more efficient, accessible, and easy to use services. These changes will take effect of December 1st, 2020. Forms will be updated shortly. So that's what we're going to kind of go through today so that you guys have an understanding of what is on the go. Even though I don't understand adjudicators want to do. As you know, there is the section of evidence. So now they want you to email your evidence to the Landlord and Tenant Board. Let me see here. I actually might be able to get someone who's had a firsthand experience with this on tonight. So we might be able to get her on in 15 minutes. So ideally, what's the Landlord and Tenant Board is allowing tenants to do, and of course landlords, is that we're going to be able to take the information and the documents and the evidence that you have, and that you're going to be able to give it to the Landlord and Tenant Board 7 days prior to a hearing. Or sorry, that was 5 days. Hold on. 7 days, 7 days prior to a hearing. So now that you have your tenants are getting notified by email, I think landlords, you need to make sure that you are indeed checking your email. If you are going to get notified of your hearing, it could be inside of your email inbox. And I would highly suggest that you take the new email address that is on, I will actually put this in the comments right now because this is something big where they've changed their email address. And I want to make sure that you guys are aware of it. So it's the portal in itself. So I'm going to get this put into the group for you. But in reality, the tenants are always going to have that option to ask the adjudicator to share their evidence, and the adjudicator can actually allow it. Heather said all of her hearings information was sent via email. That's great. I don't know why they haven't done that sooner, but they are willing to make in-person. They're saying that there could be in-person hearings happening in the fall, they said. So I'm not too sure if they stopped that. But we have to know that it's just because they're going digital, that doesn't mean that they're going to be doing all digital. There could be indeed a time frame where someone wants to meet in person and they will have to accommodate. Let's see here. You should see me reading all of this. It was absolutely crazy. So the guide to the RTA, remember that piece of package that you have to send to your tenants, informing them of their rights and responsibilities? We don't have to send that out anymore. That's really good. The practice of direct case management, hearings, the video, I can't even talk today. I had Starbucks. This video, phone, and written hearing to be used as mediation prior to a hearing is granted by the LTB officer who is trained in dispute resolutions. Attendance is required for both parties are expected to provide their evidence to each other at the Landlord and Tenant Board. Ultimately, the goal is for both parties to agree on a settlement. And they say that in their paperwork is that they want you to be going there with able to get that a settlement. So understand that you're going in with thought process of settling, so it doesn't have to go into a hearing. So that's when you're kind of getting to your case management. You might want to kind of put that on the side and want to get a hearing right away, but then you got to deal with the other rules and procedures that they're going to end up following. Tenant groups hijacking hearings. Oh, that's entertaining. I did find out today from someone who had a hearing is that they actually had to kick people out because they wouldn't shut up. So that is, and you can get a link, like you just, if you want to start seeing these hearings, which I think everyone does, contact the Landlord and Tenant Board. They're going to be able to set you up where you actually can get in and start listening to some of these hearings. Just be respectful, keep yourself on mute. I don't think you have an option, but getting yourself in there to listen to these type of hearings to see how they're actually handling COVID through the hearings based on COVID through the first wave and second wave. I know I got to take part in a hearing, and it was absolutely like crazy to see that we have tenants were just grasping at everything that they could possibly go at of saying why they couldn't pay rent. But the adjudicator's like, you had a job in 37 hours a week. He's like, you haven't paid rent in 5 months. What's going on here? But he wouldn't give the verdict right there and then. He said he had to actually send it through the mail. So the poor landlord's probably checked his mail like clockwork, making sure that, hey, do we have that? Practice of evidence. So I was talking to Chantel today. I'm going to actually send her an email right now because I think it's going to be great for you to hear what she was actually dealing with today, because that is something where, even though it's in the rules and regulations, sometimes these adjudicators will make exceptions. That way they can keep the hearing actually going instead of adjourning it. And we'll get into what adjournments and rescheduling looks like as well tonight. So we got that over to Chantel. Sorry, it's not the traditional way that we like to broadcast, but I want to keep everybody engaged of what's happening and make sure you're getting your comments. Like, I'm speaking with Landlord Tenant Board on the 8th. If you're having a hearing, you see what's happening, we need to know what is happening so I can take your voice over to them. The system, I heard that the system was down as well, so it's kind of, and then they talk about a digital, so I can see, Elaine, that they are working on it. The ombudsman is still actively investigating the Social Justice Tribunal, so I think they're coming down to the wire trying to make these changes. Okay, let's get into we're going to go back to the evidence side once I get Chantel on, and then we can kind of have that conversation. Okay, so adjournments. So the one thing that I liked about things that were changing is that, and it's going to be about clarification with the Landlord Tenant Board when we actually do get to speak with them, because it talks about it. If you are not able to attend your hearing, you cannot participate in the hearing. You should give someone written permission to represent you and participate on your behalf and email it to the board in advance. If you are a person who has filed a motion to set aside an order and you do not attend, you have someone to represent you. This means the Landlord Tenant Board can hold the hearing without you, and your motion to set aside will be denied. If you are a respondent and you do not attend, or someone to represent you, this means the Landlord Tenant Board can hold your hearing without you and make a decision based on the claim of the other party. So I guess landlord doesn't show up, it's all squish. Tenant doesn't show up, it's obviously going to continue to keep happening, even though the tenants always have their option of saying why they couldn't attend the hearing. Now that they have adjournments, there's reasons of why they could allow an adjournment for the tenant. But again, if you can have someone represent you, and everything is now, evidence is giving 7 days before, why are we even allowing adjournments? They're giving lots of time. They have a lot of communication on the Landlord Tenant Board website and through communication about their hearing where they can get legal advice. So unless they say that they can't, they want to be able to have a legal representation, but the legal representation is unavailable on that day, that's when they could potentially, give the adjournment on that. The short adjournment may be allowed when a representative has been retained but is unable to do those dates. So that's how you wonder, hey, I have a paralegal, but is that paralegal available on that date? That's where it's like, can that be abused? That's where we want to be able to see if we can figure out ways to give lots more time so the tenants don't have an option to use this to just prolong the eviction process, because that is just the loophole in itself. So now they've talked about the condition of an adjournment. The board may impose conditions of the adjournment if granted. Example, the condition that is imposed. The parties must disclose to each other the evidence, further information about the position of the specific deadline. In a case involving a claim for the rent arrears, the member must decide that the tenant should pay some rent arrears either to the landlord or into the board's trust account. By the way, there's going to be a payment site where they're developing an online payment portal. So that's a little interesting to see that it's an online payment portal, and tenants can indeed pay their rent to the board. But where does that go after? Because I know we had some changes where they could pay it in trust, and the board would give it to the landlord, and then they changed it where the money in trust would go back to the tenant. So I like to see what this online payment portal is going to be like. A lot of money is being spent on inefficiencies, but then They say they granted the party that requests the adjournment or either party except the most exceptional circumstances where the other party consents to an adjournment request. The cost rewarded to the party opposing the adjournment to compensate from the cost resulting from an adjournment. So if a tenant wants an adjournment and you're telling the tenant that they have to pay the landlord now because of the adjournment, how are we actually going to collect? That's the question that I would have with the adjournment. But again, why are we actually hosting these type of adjournments anyways? They know that it's coming. Let's have a lot of time given to all parties so that they know what is happening and they can prepare for their actual hearing. Now I got Chantel on, so we're going to bring her on so that you guys can hear about her hearing and how the evidence. So you remember 7 days prior to your hearing, you have to have the evidence in. So let's get Chantel on. Hey, Chantel.
Hi.
Do we have a black screen? Do we have your face, or we're just no face tonight? There we go. How are you?
I can, yeah, there we go. I'm good. How are you?
You know, just trying to
Can you hear me okay?
myself. I can hear you. Can you hear me?
I can hear
you.
you.
Hear me? Do I need to do the stuff on all those rehearsals? I only know my name.
Maybe. I'm just trying. I'm going to mess with my audio here.
So keep on talking. She's going to come back in, guys. Okay, before she comes back in, I want to be able to jump into, let's get into what really is irking me. I can't even think about any. Oh, Chantel's on. I won't even talk about what's upsetting me right now with the Landlord Tenant Board. Hold on. Let's get her in. There she is.
There we go. Can you hear me okay?
We can hear you.
Okay. Okay. So you wanted me to just talk about my experience today?
Yeah, talk about your experience with the evidence and, your experience, how, your overall goal. What would you want to tell us what happened and then tell us what you want to see changed after?
Okay. So essentially, I thought that it was a private, I thought that this was like our court date, our time was for 11:15 this morning, and it wasn't. It was just a group. So essentially, everybody that had court dates for today met today. They did a roll call to see who was in there, and then they went case by case. Our case was actually the second one that was called, but right off the bat, he asked if she was gonna challenge with 82 or 83 forms, and she said she was, and they said, well, they hadn't received them. I said I had received them, but I would receive them late, and I hadn't had a chance to respond to them. And he right then asked if the legal aid could send in her copy, of everything that she had. So she right there was allowed to send it in. It didn't work when she tried, so then he actually had me send it in, which I thought was kind of weird, but I wasn't able to challenge the rebuttal or anything. I wasn't able to say it's not fair that this was happening because she had actually only sent it to me 3 days prior. So I'm assuming she also had only sent it to the courts 3 days prior. So I'm assuming that's why they didn't have it.
Okay. But he allowed the evidence to come in, and if he didn't, it was going to result in an adjournment?
So he allowed it to come in. We actually ended up, we were the second case called, like I said, and then it ended up being almost 2 hours of waiting as we went back through a few times. Our name got called a few times. He still didn't have it on his computer. He was waiting for it to come through. And then when it did come through, he asked what we wanted. And I said that I personally was just looking for standard order eviction. And then I would have taken her to collections after. I knew I wasn't going to see the money, but I was going to do it anyway, just because. And he essentially said that with the new information, I could potentially end up owing her money, and that he would have to look through it. But because the time slot that was given to us was so small, that it was very likely that he was going.
Oh, it's cutting off.
To adjourn it to a different time.
So you either had to.
Can you see me okay now?
Yeah, I was just cutting off there for a little bit. I was like, we got the adjournment. He was allowing it. We just had to get that last sentence that you had said there.
Yeah. So he was going to allow it, and he essentially said that if we didn't go to mediation and. Oh
no, I'm losing you. Okay. How about if you turn off the camera? Can you turn off your camera and just have your audio? Let's see if we can kick her out and get her back in again. Sorry about this, guys. Okay, we'll send her a message telling her if she can jump back in, just keep her video off. Okay, so we'll get back to Chantal. But in the meantime, they have a Guideline 7. It is called Relief from Eviction, Refusing, Delaying an Eviction. Has anyone heard of this? Anybody? Hey, Felix. So the adjournment of the relief from eviction is the mandate giving adjudicators not only the right to deny legal evictions to law-abiding landlords, but they must, in summary, this mandate prevents the law-breaking tenants from being able to evict by serious delays or evictions. They are just some of the these are some of the qualifiers to refuse legal eviction. It would be unfair, price point, no one to assist them in seeking other accommodations, medical conditions, tenants require a 5-bedroom and none are available, becoming homeless, municipal overcrowding legislation is just a minor violation. So there is multiple different reasons why they could say they're not going to grant you the eviction. The tenant could owe you $24,000 worth of rent. The only time I see that they're not going to be able to do this is if they have three different points here. In case involving the allegations of a tenant's fault, such as eviction for arrears or legal act, considering whether the reason is serious enough to justify an eviction. Number 2, in a case involving a landlord's allegations of interference with reasonable enjoyment, considering whether refusing to evict the tenant will result in an application against the landlord by other tenants for interfering with the reasonable enjoyment. And number 3, considering whether refusing to evict the tenant will result in unreasonable financial hardship to the landlord. So if you're not qualifying in those 3 and the adjudicator feels that there is they can exercise their powers, they can actually refuse the eviction or delay the eviction. Now, I never seen this in Bill 184, but I guess it's technically condo, the COVID related. The tenant's conduct has been an important consideration in the past decisions. If the tenant got far behind in the rent arrears, but recently made extra payments to catch up and owes relatively little now, the discretion may be exercised in their favor. They said in the case of a persistent late payment of rent, the tenant had financial problems when becoming unemployed, but the months since they found another job. Payment has been right on time. The eviction may be refused despite the early months of late payments due to the tenant's good conduct. I don't even know if you guys want me to keep reading this because I feel like crying every time I keep going down. A tenant is not accused from paying rent if the landlord has a greater financial resources, a public agency or a large corporation landlord. Other relevant factors may include whether the current reason for eviction has been repeated, the impact of the tenant is having a landlord and other tenants, whether the tenant has taken positive steps to eliminate the reason for the eviction, and other indications of good faith on the part of either the landlord or the tenant. So we have a concept here where if you think everything is going in your way and you think everything is going right because you've done all your paperwork, and here at the end of it, they're just going to deny the eviction or delay the eviction, how are landlords want to keep operating in Ontario when the Landlord and Tenant Board, it all depends on what type of adjudicator you're getting. So if you do have an adjudicator that you're going to be getting, please let us know their name in the group. We want to know which ones are there trying to help us and exercise just the law in itself. They also usually has that, although the time period set out, there's no time period set out in the RTA, the board provides that the tenant has 11 days after an order for the arrears for rent termination. They've now changed that to 12 days. 12 instead of 11. So we were actually hoping and advocating for that we don't get, sorry, Chantal. we were actually trying to eliminate this 11-day standard eviction, and the order should come in the date in which your hearing was actually granted. So I'm looking at, again, bringing this voices to the Landlord and Tenant Board, because 11 days gone to 12 days, you know, this needs to be changed. And I think it's going to be changed for the fairness of all parties that are involved. Let's see, I got a whole bunch of circles going on here. Even in the circumstances to not justify a refusal of an eviction, the member may look at the same issue of unfairness to each party and decide whether or not to delay the eviction. Eviction may appear to be unfair and no other accommodation is available to the tenant, social housing tenant. However, a case in which the landlord is in a better financial position than the tenant does not justify refusal of the eviction. The tenant lack of resources will be considered as a reason to delay an eviction, not to refuse it. However, all circumstances will be considered. Let's see, we have a Facebook user. Is it legal for the tenant groups on Twitter to screen record hearings on? And that is a good question. I'm glad you actually brought that part up, because inside of the paperwork that they give you for a hearing, it says you do not provide, let me see here. This is where they tell you, do not record the hearings. You do not have permission to record the hearings. So I'm kind of shocked to see no recordings. So number F on the information about video hearings, you go to F and it says no recordings. You may not record any proceedings. So how that lawyer, I believe it was for the tenant, who recorded it and gave it to Toronto Star, and here they're already breaking the rules regarding sharing that information. Rent arrears during COVID. I've been a very strong message out there, making sure that you are trying to work with your tenants and getting into the payment agreement plan. That is out there for you guys to show that you're trying to work with it. But the sad part is, if you're working out an agreement, and you got to have an L1 application actually in play before you can actually file this with the Landlord and Tenant Board. But if your agreement plan and it breaks, they're saying that you can't bring this information to a hearing because it's not going to be considered to be evidence because they broke their payment arrangements. So how the payment arrangement is going to work with these type of hearings, I'm not quite sure how that's going to work, but keep doing it, showing that you're trying to work with them. Hold on, I think we got Chantel in here now. Hey, Chantel, I think you got your mic off, so I don't know where she is. She should be here. Yeah, I agree. Who can say what the landlord's undue financial hardship? But do you just say it's financial hardship? Do we have to show proof that it's financial hardship? That's going to be the question of trying to stop an adjudicator from delaying or refusing to evict a tenant. And even for, do we have you, Chantel?
Can you hear me okay?
We can hear you.
Okay.
Let's get you back. I was just getting into the concept of the rent arrears and how the adjudicator can actually refuse or delay an eviction just based on what the tenant's going to tell them.
Yeah. It was pretty disheartening, considering I had to get my information there on time, that she would have just been allowed whatever she wanted to submit right then and there.
Now, okay, so now you got your hearing. We talked about you thought it was a one-on-one. Technically it was a big group, which I was shocked to see the same thing. But hey, if we can get them all done and have them on the line ready to go, it's I think that's more of a streamlined approach.
Yes.
And now that you had your tenant who didn't get the information to the board in enough time, but the adjudicator had accepted her information in exchange for what?
And so he just was going to take her information. She threw her in her evidence late. She essentially wanted to apply. She was saying that she wanted 20% off of her rent for a few things, which when she sent it to me, she gave me 3 days notice. And I immediately asked, one of the things she had put in was about something my realtor had said. So I immediately went after the realtor and said, hey, can you throw me something off that would deny this? And she immediately wrote it and said that she would be part of it if we needed her to, but they didn't even get that far. He just essentially said, if I take this, I'm going to review it, and because of the time slot given, we're probably going to have to do this on another day. So I could have been waiting months more to get her out for essentially no reason, because anything that she said I was very easily able to discredit.
So it's just about having the proof to back it now that you need it, that you couldn't do right there and then as she sent her evidence.
Yeah, like essentially it was, I did have some stuff prepared because I did get it 3 days in advance. So I was able to get a few things put together, but then it would have been the fact that he let her do it right at the last minute. Like literally as she was there, send that information in, then I would have had to send my information in. He would have had to review everything, and there was just no time for that.
Now, my question to you, Chantel, is that if you are bringing an application to the board for non-payment of rent, and when they send your hearing documents, what the hearing document that you get from the board, it gives you a sample, doesn't it, to say what kind of information do you want to bring to the Landlord and Tenant Board? And did you receive that within your package?
I absolutely got the entire package, and she would have also, we were given this 30 days at least before this court date. She claimed that 3 days ago that she didn't have access to a computer or a printer, so she just wrote off an email and sent a body of an email pretty much where she just wrote up what she thought she wanted money off her rent for, and then she also sent a couple screenshots and a couple pictures.
Well, hey, at least we got something there.
Yeah.
At least it was right there and then. I'm just surprised that he was able to take the evidence from you and he wasn't getting it from her. Because I know that when I got the package that was from that was sent to us from one of our members, is that it gave you a sample of if you have any maintenance issues that you want to bring up, you got to put it down. And here's a sample. You know, roof was leaking. I let the landlord know on X date. This is what I want, 15% off of my rent based on the inconvenience. It was kind of like, I wonder if that's going to feed more maintenance complaints and more evidence being pushed to the Landlord and Tenant Board. And also kind of feeding the tenants like, hey, you know, here's a way for you to get money back from your rent. Like, why is that even included? Everyone knows if you have a maintenance issue, one, you could deal with property standards, and number two, you're able to go ahead and file an application at the Landlord and Tenant Board.
Yes, exactly. And it's ridiculous that they're going to set this as a precedent, because then what's stopping every other tenant from doing this at the last minute, pulling this out so that they essentially end up with a couple more months of rent?
And that's why we're looking at the concept where in Guideline 7, they say eviction for failure to pay rent, refusing or delaying an eviction is at the adjudicator's discretion. And in some cases, it's refusing or delaying the eviction is considered mandatory. So it's like, is that how they're able to deal with COVID, even though people A, had their jobs, or B, they had the CERB benefit? But there's also government services that are out there to help tenants out with their rent arrears. And that's what I think. I would like to applaud all of our group members who were commenting on Rima's post regarding the eviction factory, because there is government agencies out there that are helping people who's able to help them with the arrears or to help them out with their last month's rent deposits. Why isn't our government trying to direct their tenants to these type of services in order to keep them in their homes? But instead, they rather have our adjudicators mandate it, and where they can refuse the eviction based on the concept that they can't find accommodations or the price has dropped so much. Like, how is this even becoming homeless? Like, if they said, hey, I'm going to become homeless if you evict me right now, would the adjudicator prevent the eviction from being put through? And if so, why is it up to the private landlord in order to do it? Anybody? No, this has gone to, there's more that's happening. We need to get this more on a streamlined approach. This is still complicated. It's gone to the concept where you're going to need a paralegal to help you navigate through this situation, or can we indeed have someone else represent us, just like tenants can pick someone to represent them? So it goes back into why we're not going to need the adjournment section. But again, it's another way for the tenants to avoid the eviction. Now, everyone is knowing that with the eviction for personal use and demolition of repair and conversion, a lot of that is pretty straightforward from what we've actually have been learning through just the normal N12 and the N13 notices. This is why the hefty fees of $25,000 gone up to $50,000 is gone crazy for unlawful evictions. But again, it's gone to the landlord is attempting to enforce the order. The landlord has an obligation to inform the court if inform the court's enforcement office of any rent payments the tenants made that are not reflected to the order. So a concept of the eviction for failure to pay rent, and then you have landlords trying to take over their own personal use, and all of those together, that adjudicator can still go ahead and avoid the eviction and delay the eviction. We're going to get into Felix here. I hope everyone can see these comments. I know if you're on YouTube or my personal page here, no exempt. I've been in tenants of no. Oh, so hold on. The way that it's coming up here. Here we go. So can everyone see this one? I hope so. No, I've never used this feature before. It's great. No, any tenants on the form social assistance, let the government figure out how the housing them. Okay, man, that's a solution. It's going to get us in trouble if we come out publicly to say so. Unfortunately, this would, you know what? In reality, is that landlords are here to help with this housing crisis that we're in. And I think they're feeling the burn a little bit more because of the concept that landlords are jumping out of the business and they're starting to take over their units for their own personal use, or they're taking it off the market so that they can sell it to another person, in which they're able to try to get them to take it over for their own personal use. I think I have Felix up on my screen. Chantel, can you see Felix?
Well, I saw a thumbnail. I don't know where everything's gone again now.
So I just want to, I think if I click the name, it actually pops up on the screen. So I think that's pretty good. Let's see what we can do with Connie.
There we go. I can see Connie.
Perfect. What is Connie saying? Government downline unreasonable responsibilities. The landlord says they have no legal recourse or zero funding to support the rules upon. Yes. Now, if I want to see your comments. We got the Landlord Tenant Board on the 8th. Obviously, we're not happy with the concept that they can choose to avoid, to delay the eviction. I like the fact that everything is starting to be streamlined through email, but I think the standard lease that is out there right now needs to have the email address that will be used to send these notifications, and have every landlord and tenant program them in as a contact in order to make sure that their hearing information is not going to spam, in a way to kind of keep this process going and flowing nicely. What's this one? Who's going to get the landlord's business now? My gosh, no one. I know we even have like the Airbnbs have been severely affected through COVID, as well as student housing. Now there's the taxes on empty units now that's coming up, and people who are outside of Canada trying to invest inside of Canada. Like, I don't think we really see the effect that's actually happening here, because more and more people have. Chantal, you've been in the group. You see many posts of landlords trying to get out. What's your thought process? Like, what do you think about that? Do you see it?
People trying to get out of being landlords, like people are selling their properties, you mean?
Yes.
Yeah, like I understand where they're coming from, because we just need more rights. It's people are getting sick of being treaded on.
And that's the problem, is that we're sitting here trying to run a business, and everyone, we always have that thought process that it's an eviction, that it's an investment and it's a retirement plan, and everyone thinks, well, sometimes investments don't work out very well, so this is the concept that you need to understand. But in reality, we it needs to be treated as a business, because with our business, we're actually providing a necessity to Ontario, and we just want some support from our elected officials so that we're able to keep conducting ourselves as landlords. But the way that they keep giving the rights and to the tenants, and the bad tenants at that's going to really go back for the government, and instead you're losing more landlords and you're just needing more government housing. That's true, Felix. This is, come on, guys. I want to keep popping you guys up on the screen like that. This is crazy. You get to see my reaction to all this stuff as we keep broadcasting out to all of them. We do have this concept where, even though the Landlord and Tenant Board is starting to speed up their hearing, it seems their landlords are very happy with how things are technically playing out, but we need to make sure that you're still connecting with the Ontario Ombudsman to get your complaint in there. Also CC your MPP, the Minister of Housing, Steve Clark, as well as his assistant, Parm Gill, and we have to keep the momentum going, because this is something that we're still trying to make these changes, and they're giving us timbits, and we just want the whole donut into helping us keep providing more rental units to the market. Because in the way that our tenants are abusing and looking for loopholes, trying to avoid the eviction process in order for them to stay in the units and cause more damage, it's absolutely disheartening. If you looked at our last video, we had a landlord a tenant owed them $43,000. And that's not even including the utilities that they had racked up as well. Like, when are we actually going to sit here and say enough is enough? And what do you say? How do you stop? How do you fight back? Is it a protest? Is it a petition? Is it contacting all the MPPs? But you can see the MPPs now fighting each other. So that's why I became such a strong advocate for Landlord Credit Bureau, because even for the concept that someone can have a bad credit, but if you get to know their payment history, that's what we need to be doing. And you can report your past tenants going back 6 years into Landlord Credit Bureau, and not just put your bad tenants in there. It's about putting your good tenants, help your good tenants build their credit, so other landlords know, hey, you got bad credit, but hey, look at your payment history, or we've seen that your credit has improved, and getting them to do that. I just want to jump in some more comments tonight, just because I think a lot of this is going to be up in the air with all these different types of evidence and how it's supposed to go. It's still going to be up to the adjudicator to see how this hearing is actually going to play out. And that's the sad part, is like, I understand that we're getting them in there and they're appointed and there's a process, and now there's a conflict of interest that could potentially land them in by trying to give these type of judgments out there. But they need to start reading towards the lines, and we do have a couple of solutions that we want to be able to propose to the Landlord and Tenant Board on the 8th, and it involves more of a software that's going to give us, access to the whole situation versus just the application that is at hand, to help them better understand the situation before they make a judgment. Let's see, Derek. I think Derek's there. Do you want to scare the government? Sell your vacant properties and put in conditions the future use of the property is prohibited by being used as a rental property. That, you know what? A lot of landlords have said that to me. They said that they are going to make sure that the buyer is planning to move into it themselves. If you're forcing them out of the market from being landlords, they're going to make sure that they try to do whatever they can to make sure that they're taking a rental unit off of the market. My goodness, for the almost 3 months and still have not had an order. Denise, what was did the Ontario Ombudsman Office help you get that? Almost 3 months and still had not had an order. In 2000, I took the Ombudsman Office 1 week ago to get my order. Wow, that is crazy. I knew they were behind. I know we just had a landlord call us, and they were on the 6th, it will be 30 days. So it's really, and I know that on the 1st, they said that their program where they write their orders were down, and they were hoping for it to be back. So thank you, Denise, for be able to put that up there for us. Students should have no choice but to have the government pay the landlord directly. If the government responses to the person on the assistance, but paying rent, that is their money. Do so what they want. And This is Debbie. That was great that you put that there, because right now, like we talked about, that there is government agencies out there that has the tenant apply to show that they had no money and that they're able to get rent relief from these type of agencies. But again, will the tenants actually do it? And B, did they have money, or don't they have money in order to qualify for this? Let's get our landlords being able to apply on behalf of the tenant in order to make sure that it's going to them absolutely directly, because this is where we're seeing rent relief for commercial properties, but you're seeing nothing still quite out there. You just talk about putting more funding into service managers, which a lot of the regional service managers run these type of programs. But we have to, a lot of people are a little nervous now based on, the second wave, the numbers increasing, people going from red to gray. And what does that look like for an eviction ban when we have our NDP who thinks that everything is free and wants to get an eviction ban on the go? And we're saying that you're going to be losing a lot more housing stock if that's ever implemented. Once again, landlords already were struggling through that time frame, and the landlord's bills were still there. So this is why we have to get ourselves more established to keep fighting back and making sure that you're telling us your experience. The government continues the path. There will be much less affordable housing for those who require roots. Everyone can read that there from Felix. The alternative is that the government breaking their heads how to accomplish this, and landlord clearly continue losing the interest in both becoming landlords and remaining as landlords. It is, like, especially where we have landlords who are trying to, or potential landlords trying to join our group, and they said, oh, I want to learn. I really want to learn how to be a landlord. I'm excited, but I've heard some nasty stories. And it's like, I got some pictures that I'm going to post, guys, after this video, because I got a sent from a member, and I think it was honestly the worst damaged unit I've ever seen. I look at the concept that the police are not getting involved when it comes down to, trying to get the police involved to deal with the tenant. But if a landlord locks out their tenant, then the police are definitely involved. It's not a landlord and tenant board issue anymore. He even has it on their radio, landlord and tenant disputes. So you can tell there's probably happening a lot more, and our landlord and tenant board is not doing their job to help mitigate. Just for the payment agreement in itself, you have a landlord and tenant can use this form when the landlord has filed an L1 application to evict a tenant for non-payment of rent to collect the rent the tenant owes, or an L9 application. Read this information over carefully before filling it out and signing an attached payment agreement form. You may want to get legal advice first once the payment agreement is signed by the landlord and the tenant in it is a legal contract. You do not have to sign this agreement if you do not agree with all the terms. If the landlord and the tenant do not reach an agreement on the terms, including that happens when a payment is missed, the landlord and tenant board will hold a hearing and a board member will issue an order. So again, they've changed it a little bit from their first initial one. It was like, you do not have to sign this agreement, but didn't give any more verbiage after it. So we can say that they listened on that part. So that's really good there. But being able to get through your hearings right now and making sure that it seems like what you have to do as landlord is to talk about how this is affecting you for your financial hardship, because it seems, or another tenant is going to file an application against you if you're not granted the eviction based on your tenant situation. Mike, we've been banging our heads against that for quite some time, knowing that a tenant can damage the place, and no matter what, it's not a criminal offense. But then again, if you're opening up your unit to someone you're supposed to be able to collect rent from, and then they're not paying you, how is that not theft in itself? And people are getting away with it. Now, you recently seen that there was someone who turned 12 luxury homes into rooming houses, and they now actually had to get charged $36,000. If not, they could potentially see some jail time. Like, how far does it have to go so that you can actually work that into our situation? Now, people probably don't know, like, I have a family of tenants. My husband is the family of landlords, and now I'm just kind of smack dab in the middle. So when I give a situation, I really want to see this as a solution for both good landlords, good tenants, and of course the taxpayers. If all of you know right now is how much we're paying to keep local shelters going, or to keep the emergency shelters. Like our region had paid over $400,000 for 70 beds just between two cities. So how is this actually helping their housing sector of providing more when they're just throwing away money and wasted money for that matter? Now you have the concept of, the hospitals. If people can't find a suitable accommodations, they're actually in the hospital, and that's a lot more expensive to keep people in the hospitals as well. And they can't keep building government housing. Like we had our director of housing in the region of Waterloo, and she's like, they can't even keep building it and supplying it fast enough than the people who are wanting on their list. So it's not only that the Landlord and Tenant Board needs a review, the RTA needs a review, you also need to consider the social justice, the social agencies that are out there. They also need the review. They need to tighten up the way that they're managing their own rental housing, because of the fact that there's so many people that could pay market rent, that is financially set to pay market rent, but they're still taking a unit in social housing away from someone who actually can't pay the current market rent right now. So we got a lot that is happening in the last couple of months, really, of when the eviction was going to be lifted, now when the Landlord Tenant Board is going to be operating, how is that going to be operating? Obviously, they're still working things out themselves, but I'm hoping to have more of a feedback from the Landlord Tenant Board, knowing what their direction is actually going to be in. And still, I need all of you to be very I need you to be very vocal on these groups that are out there, and I need you to be vocal on the elected official groups, because they make this sound like this is an eviction factory and that these tenants are becoming homeless left, right, and center because of what's happening and how these hearings are now actually on the go. And that's definitely not the case. We have a business to run, and unfortunately we're not able to run it if we're dealing with a broken system, just like we're able to apply our applications online, but only L1, L2, T2, T6 applications are able to do the e-file. And if we can start sending this information over to our adjudicators and to the tribunals by email, which that's what they encourage us to do, then we should be able to have some more of an e-file. But I would like to see our fees at the Landlord and Tenant Board dropped as well, because if you get to look at other provinces and how much they charge to have their issues dealt with at the tribunals, it's a lot less. How come we're not, our fees are just keep going up and up and up, and half of the time our tenants are not paying that fee. They're getting the fee waived. I would like a fee waiver for landlords if possible, especially for the ones that have been dealing with no money for the last year. So we got, we need a class action lawsuit filed against Ontario Municipal Government and Landlord Tenant Board. You know what, Felix, I've talked to so many landlords, lawyers, and they keep saying that the best way for us to make the change is to lobby the government. And I don't think that's, we're getting crumbs by lobbying the government for 10 years. That's why it's gone to the concept that we can't be looking at the government for all of our solutions that we need. And that's why I keep telling everyone that our game changer is Landlord Credit Bureau. It's going to help those good tenants look a lot shinier than the rest, and it's going to be able to protect the landlords as they do their tenant screening and feel that there's repercussions of it. Even for a lawyer that we connected with, they wanted $600 for a conversation over the phone, $10,000 at a retainer, and then it would have been $250 an hour. So we can definitely do that, but that was only for the part of getting the eviction ban lifted. I do know there is a group of landlords, lawyers who are trying to go after the tribunal because of their inefficiencies of what they've been doing with the Landlord and Tenant Board. But that, they said, is going to be a year out, just because they have to get their paperwork together. And then after the year, they start getting the affidavits from members. So I'm hoping that through our complaint process with the Ontario Ombudsman is that we're able to get them to make some of these great recommendations that we're able to give to them to benefit all parties involved, and seeing if they can make that report. Government's greatest cycle of social franchises with zero planning of an end game. They cannot find better solutions when all funding goes to the band-aid knee-jerk solutions that don't fix the root of the problem to the homeless. Well said, Connie. Well, I should have had you on here tonight too. It's a vicious cycle that's being put around, where we're always going to need these agencies. We're always going to need government housing, and we're always going to need our taxes going up to cover all the needs that we have. But sadly, we have when we sat with Christine Hogarth, she said, why is the government in the business of housing? Why are we competing with other businesses? And that's the concept that they talked about. We're allowing landlords to hire private sheriffs. But again, that was when the sheriffs were very tight with their time, and, you know, hiring another private bailiff to get it done quicker wasn't such a bad idea. But because of their break, they're still playing they're not playing catch up anymore. They're actually looking for some for the evictions to actually enforce. But we have to get ourselves into a system of looking at ways to better protect yourselves once you have your bad tenant out there, making sure that we're able to help each other with the screening process, because then we don't have to deal with the Landlord Tenant Board, so to speak. But we're not done. We had a great conversation with them in August. They loved the ideas that we brought to them. That's why they've reached out again to talk on the 8th of December. It's been crazy with the move here with the kids, and I have some, you know, exciting news that are going to be coming in the new year, but I can't say anything, so I got to keep my mouth shut. And I'm going to tell you if I keep talking. So we're just going to skip that and just say, tune in the new year to check the page to see what new is going to be happening. But I want to thank everybody for watching tonight. Just know that there is the Landlord Tenant Board website, that save that on your phone. Just constantly read it. Constantly read the Residential and Tenancy Act. It's the best thing that you can do for yourself. We're going to get a lot of clarifications that are going to come from this whole mess that was all over the desk. Like the desk is covered in all these different types of changes. We're going to get more clarification onto that, and then hopefully bring back another video to let you know how our meeting happened on the 8th. And until then, we're going to have a thread in our group that if you're dealing with your hearing, and we want to know what that's all about. We want to be able to see exactly what is happening so that we can bring that information to the Landlord and Tenant Board. I'm afraid the Landlord Credit Bureau isn't helping in our case. Our tenant doesn't seem to mind it every time we submit the non-payment of rent. The one thing that you want to see is that sometimes when you're able to go and report your tenant to Landlord Credit Bureau and you're playing with your premium account and they're able to get notifications stating that they've been reported, and they get reminders that your rent is due, and knowing sometimes when the tenant has that good credit, they jump on it right away. But knowing what you're doing now is that when that tenant is now being affected and being reported to Equifax, you're now preventing that tenant from going to abuse the next landlord. It's sometimes it's like, well, why would I do that? You know, I want them out of my place. They're eventually going to be out of your place. The sheriff in itself would still evict that tenant. You want to make sure that we're able to go ahead and try our best to get that tenant out of the system and the rotating chain of going to landlord to landlord to landlord, because that's what's happening. These are the professional tenants that we're talking about. When we talk about evicting tenants, and when I have my eviction day t-shirt on, this is not about the people who fell down on their luck and they just need some help and guidance, and we need to be humans to them. These are the people who are abusing the system. And that's the ones that we're actually here talking about. So when you look at the concept that if all landlords are reporting their past and good tenants being able to be reported to LCB, you're going to be able to make that behavior change, knowing that there's repercussions for their actions. But Brianna, if you did you have your court date yet? Do you have it? Like, we want to be able to kind of follow up with you on what's happening in your situation. But believe you me, I have my tenant, he called us within 24 hours right away from knowing, what's this? I couldn't even try to mimic him right now because I'm trying to make myself laugh. But give it a try. I'm glad that we were able to hand out those tickets, those premium accounts to our 4 winners there. I can't wait to hear their feedback from it as well. But this is something where we can't be just looking for the government all the time. I will continue to keep advocating and getting their attention. That's a part of the news that we're going to be able to share with you now in the new year. But make sure that you're getting your complaints into the Ontario Ombudsman. I can't stress that enough right now. We need to be able to get them to get a report of recommendations of what needs to get changed. But I hope to be able to be more involved with the Landlord and Tenant Board and help them with, me being on the ground in the trenches, able to give your feedback to them in order to make this a fair and balanced process. Because right now I can't see anything in these papers that it says, hey, it doesn't really quite state this in the RTA, but adjudicator can go ahead and rule for the landlord and deny the ex parte order or the station of the motion to stay. And come on, give us some tidbits too. We deserve it, because a lot of these landlords out there, they rely on this type of income. It's not that it's their rainy day fund or it's just a retirement plan. There's a lot of landlords out there that actually rely on this income to pay their property taxes and to pay their mortgage and their bills. And this is where we're just asking for the type of freedom to be able to construct our business the way it is. I think it's too heavily involved by our government, and I think we need to be looking at other provinces such as Newfoundland, where landlords and tenants, I believe it's $20 to have your case heard, and the landlords represent themselves, the tenant represents themselves, and it needs to be more of a black and white situation, because rent in itself, it's pay your rent. And if you can't pay your rent and you wait at 5 months, what are you supposed to do? These landlords are going to start taking things into their own hands and getting themselves into trouble because they're not being equipped with a better system that protects them and allows them to be good landlords. See, it goes down to, why are we letting people getting away with fraud? Why are we allowing us to get away with people with damaging our units and not being criminally charged on this just because we have a landlord and tenant title? And this is where we have to start making some modifications to that so that it prevents the tenants from actually doing the type of damage that they do. Because I'm sure that all of us had that fear, you want to give an N5 or you want to give an N4, but you're worried about the retaliation of our tenants. Just like some of our landlords are afraid to report their payment history because they're worried about the retaliation of the tenant. But you can also put that in review that there was damages occurred with that tenant, and you can put that on the review as well, just to make things fair. But we have this meeting. I'm excited for this meeting. I want to be able to get more information of, what their potential changes are, but knowing that they got that digital stampage that they're trying to work with their orders, that could be the game changer. But it still said that they have 25 to 30 days to give us the order. I'm hoping that number changes as they get into more digital. So I look forward to asking these questions. I'm going to post a link to where I found all of these documents. So I want you guys to read it, please, and give us your questions. Get us what you want more of, because I know right now they would talk about utilities. The utility section in here is very gray. Having filed your application to the Landlord and Tenant Board after your tenant had moved out versus filing it while they live there, just make sure that you're doing the proper paperwork so that you don't get caught. You're not sitting there going through the never-ending loop of waiting for a hearing. But that is what I'm going to leave you guys with today, is making sure that you're reading up on all of the Landlord and Tenant Board forms and the new changes that are happening. I'm looking forward to bringing you more information coming up now after the 8th at 12 o'clock with the Landlord and Tenant Board. I'm excited to be able to give them our thought process on what's happening so far and get more of a clarification of what these adjudicators are thinking, or when they will enforce the refusal or delay in eviction. So stay strong, guys. Just know that we are doing our best to make sure that we are fighting for our rights and to fighting for our business. So keep your comments going on this video. Make sure that if you have anyone, just add them into the group. I'll see the notification that you've added them, and we'll try to get them in as fast as we possibly can. We do have a waiting list of people wanting to join the group, and stay tuned to our meeting our little Facebook Live that we are going to do after the 8th. So if you have any questions, I'm looking forward to talking with you from now until the 8th. If you want to have a personal one-on-one, send me an email at olwlandlords@gmail.com. We'll arrange a time so that we can chit-chat and get your ideas, because all these are not mine. I wouldn't be able to do what I do today if it wasn't for the members in our group. So just keep your comments going. I know that we're always afraid of posting and you're afraid of backlash from members and stuff, but you know what? We have our freedoms for a reason. Exercise them. Say what you want. There's no question is a dumb question. The only thing that's dumb is not answering your question or not giving a post and not giving your opinion. So make sure you guys are helping one another, be kind to one another, and understand just because someone doesn't agree with your opinion on things, you can still like each other as humans. Don't worry about that. But we'll always keep our group entertaining as much as we possibly can. And I'm looking forward to being able to share this exciting news with you in the new year of what's happening. I gotta get off. I gotta get off, guys. Thank you so much. Until we do this again, happy renting.